Okay, where were we? Thank you. All right. Commissioner Elam.
Thank you, Mr. Chairman. As an aside, before I continue my motion, I'm looking at Mr. Witt right now, who represents the Solar Business Alliance, and he's free to shake his head one way or another when I say I dare say that the solar folks have achieved more in this docket, perhaps, than they have in several prior proceedings. Solar will be working better as a result of this case than it has been. I pick back up. Move that we approve the proposed merger with conditions to be outlined shortly, and adopt Plan B levelized, including a 9.9 rate of return on equity, with rates to be established accordingly. In May of this year, an average SCE&G monthly residential bill totaled $147.70. At present, under this Commission's legislatively ordered temporary experimental rate, such an average customer pays $125.34 per month. I would note that approval of Plan B levelized would result in an average monthly bill of $125.26 for an SCE&G residential customer using 1,000 kilowatt hours per month. I believe that Plan B levelized provides significant customer bill relief for SCE&G's customers without damaging SCE&G's creditworthiness or putting at risk SCE&G's financial soundness or ability to provide reliable service to the company's customers, all of which are of great importance as the ratepayers. Plan B levelized provides for SCE&G Dominion to voluntarily write down capital costs, which were $4.7 billion by about a little under $2 billion, including impairments taken to date. The remaining amount is about $2.7 billion. These benefits can only be provided to SCE&G and its customers as merger benefits. No other proposed plan can provide the same combination of benefits that Plan B levelized can provide. I move that the other proposed plans be rejected. I note that the benefits available to ratepayers with the adoption of this plan are in addition to the benefits that ratepayers will receive from the proposed settlement of the civil lawsuits. As part of the project, SCE&G undertook a major expansion and strengthening of the backbone of SCE&G's transmission system. The total amount invested was approximately $322 million, and the company has testified that all aspects of the project will be in service as of January 31st, 2019. Only the financing cost associated with the $275 million in capital is in rates today, which is the equivalent to approximately $32 million in revenue requirement. The return of capital of the entire amount invested and the financing costs of the remaining approximately $47 million are not in rates today. A determination of the rate-based treatment will be determined in the next rate case. With regard to specific merger conditions, the joint applicants made certain proposals. Recommendations from other parties use the joint applicants list as a basis for discussion. Therefore, I move that we adopt the conditions proposed by the joint applicants with the following exceptions and additions. New nuclear development N&D cost recovery exclusions. In addition to the joint applicants' commitments to exclusions of certain costs to be prospectively excluded from SCE&G's N&D project rate base and SCE&G's cost of service for rate-making purposes, I move that we adopt the more ratepayer-protective ORS description of excluded litigation expenses as set out in ORS Proposal Paragraph 5. I also note that SCE has agreed to that the approximately $180 million initial capital investment in the Columbia Energy Center, a 540-megawatt combined cycle natural gas-fired power plant located in Gaston, South Carolina, will be excluded from rate base and rate recovery and therefore not a capital investment for which ratepayers will be responsible. Affiliate transactions. In addition to the joint applicants' commitments, I move we adopt the ORS recommendation regarding commission approval for any proposed structural reorganization and the ORS requirement for competitive sourcing, but with the removal of least cost language, because purchases that have the least cost are not always the most reasonable and prudent for the company or its customers because it must take into account total delivered cost, reliability, availability, and diversity of supply. However, the Commission's expectation is that absent such a showing, the company will seek out the least cost option. As for business operations, in addition to the joint applicant's commitments regarding business operations, I move that the corporate offices of SC&G shall stay in Casey, South Carolina, unless otherwise approved by this commission. Further, Dominion shall add a current member of the SCANA board or executive management to its board as soon as practicable. As proposed by ORS, I move we further require that within 3 months of the merger, Dominion and SC&G shall adopt and adhere to a code of conduct developed in collaboration with the ORS and approved by the Commission. Such code of conduct shall be developed to assure that the utility and its officers, employees, and agents act to assure that they adhere to the duty to avoid the concealment, omission, misrepresentation, or non-disclosure of any material fact or information in any proceeding or filing before the Commission or to ORS. Employee matters. Dominion has committed to minimize reductions in local employment, in part by allowing some of the Dominion Energy Services Incorporated employees' shared service functions to be located in Casey, where it makes economic and practical sense to do so. I move we require joint applicants to report on their progress regarding this commitment twice annually for the next 3 years. I would also note that Dominion has committed to extend salary protections to non-executive employees an additional 6 months to July 1st, 2020. Service quality. ORS and this commission support all of the company commitments on service quality, which should be adopted. However, I believe that we should reject as unnecessary additional ORS requests since the hearing record did not support a more severe focus on SC&G's ratepayers' service quality experience. Financial. The joint applicants agree to the extent any long-term debt issued following the merger is more expensive as a result of the merger, the cost of such issuances shall be reduced to the average for purposes of calculating overall cost of debt in the first base rate proceeding following the closing of the merger. We should adopt this proposal, and I move we reject the ORS proposal that differs from that. Community. The joint applicants commit to increased giving of $1 million per year for at least 5 years and to maintain SC&G's corporate presence in the community. This proposal should be adopted. ORS has nothing in the record or even in its proposed order to support its additional proposals on community commitments. However, based on a colloquy between Witness Blue and Commissioner Howard, I understand that Dominion has an energy share program in Virginia that is somewhat similar to a voluntary roundup program several rural cooperative utilities have in South Carolina. The co-op's program allows ratepayers to choose to round their utility bills up to the next whole dollar. These amounts can be used to alleviate financial pressure on low-income members of the residential ratepayer class caused by electric bills. I strongly encourage Dominion to consider implementing a similar program for its South Carolina ratepayers. Merger savings and rate case stay out. The joint applicants have committed that merger savings will be recovered in the next rate case to be filed May 1st, 2020. Further, that they will provide a total of $2.45 million of refund to natural gas customers as of 2019, 2020, and 2021. This is reasonable and should be adopted. I believe that we should reject as premature the ORS recommendation to quantify estimated savings. Again, Dominion has committed that a lot of those merger costs would not be passed on, if I misspoke there. Transco settlement, in that settlement, the joint applicants commit to establishing a request for proposal, RFP, for commitments of over 100,000 decatherms a day and agree not to contract for capacity with an interstate pipeline unless with a least cost provider or with commission approval. I move that we approve this commitment with rejection of additional proposed requirements as outside the commission's jurisdiction and a matter for the South Carolina legislature. I also move that we approve the settlement agreements between the joint applicants in this case and Transcontinental Pipeline, and in principle between the joint applicants and the South Carolina Solar Business Alliance with some slight modifications. I do not believe that these agreements should rise to the level of merger conditions, but should exist as separate agreements. With regard to the settlement agreement between the Solar Business Alliance and the joint applicants, I move that we interpret paragraph 3 to mean that the integrated resource plan should not be modeled with sensitivities for an imputed value of at least $25 per ton for carbon emissions for all scenarios. Certainly one scenario could be modeled accordingly, but the $25 a ton should not limit all scenarios presented, or the agreement would not be consistent with state law on integrated resource plans. Further, I move that the company's commitment to funding an outside consultant and an independent evaluator to examine IRPs shall be provided through shareholder funds and not ratepayer funds. Further, I move that the ORS proposal to return all revised rates collected after abandonment on July 31st, 2017 as a regulatory liability for refund of revised rates be rejected. The purpose of revised rates was to allow recovery for the cost of capital that had been spent in the past period. Later abandonment does not change the fact that the money for cost of capital for a given period has in fact already been spent. The revised rates proceedings approved recovery of those specific expenditures. In addition, I move the adoption of the adjustment to costs as proposed by the joint applicant's proposed order. I also move that we issue a written order further detailing this motion, and that all motions made in the case not specifically addressed in the order be deemed denied, and any unaddressed objections be overruled. I move that we instruct staff to prepare a proposed notice to customers relating to this motion, which this commission will address at its next business meeting. I move that the actions in docket numbers 2017-207E and 27305E be dismissed because of our holdings regarding the issues in docket 2017-370E as outlined above. I further move that the motion in limine as filed by the joint applicants be denied as moot. Mr. Chairman, clearly my proposed motion will not completely satisfy concerns of everyone with an interest in this case. However, I believe it has enormous value for all SCNG ratepayers, stakeholders, and the state as a whole. It's my wish that more could be done. However, this commission has to utilize the record in this case to provide the best remedy or the least worst remedy that it can under the circumstances. I believe that this motion provides great value to everyone concerned, and I move that it be granted. That's my motion, Mr. Chairman.
Thank you, Commissioner Elam. You've heard Commissioner Elam's motion. Are there questions or comments? Commissioner Howard.
Thank you, Mr. Chairman. My first thought was to deny the merger and keep SCNG a South Carolina-owned utility. However, after considerable all options, I am convinced that the merger is in the best interest of SCNG ratepayers and the state of South Carolina. I would have to accept the fact that SCNG would be financially strapped, and this would limit severely what the company would be able to accomplish. Realizing that one seldom mentioned group of victims in this debacle is the 2,000-plus employees that had absolutely nothing to do with the decision that led us here. They have gone about their work to ensure that customers have reliable electricity while not knowing what the future holds for them. When a company is in a financial bind, one of the first places to cut is the workforce reduction. Dominion has agreed to maintain the same level of employment for non-executives until July the 1st, 2020. Also dealing with reliability, one area of cost cutting is vegetation management, which could have a negative effect on reliability. In the mixture must be added the availability to excess of the capital market. At best, with a rating of SCNG would be high interest rates would be passed on to the customers. For this reason and others mentioned in motion, I support the merger agreement and Commissioner Elam's motion. Thank you, Mr. Chairman.
Thank you, Commissioner Howard. Commissioner Whitfield.
Mr. Chairman, thank you, Mr. Chairman. Mr. Chairman, you closed this hearing by stating that this commission could not make all parties happy. State law empowers this commission to fix rates and set rates and provide for safe and reliable power. It is this Commission's job, our job, to bring finality and certainty to this matter while providing maximum amount of relief to the ratepayers. Our ratepayers and our state need closure to this matter, and for continued economic development, growth, and capital investment in our state regulatory certainty is needed for us to continue and to move forward. Mr. Chairman, after nearly a month of testimony, evidence, and cross-examination, and everything included in the record of this case, I believe Commissioner Elam's motion, in a very thorough and detailed and methodical way, is the only way forward for our state. Mr. Chairman, it pains me that SCANA and SC&G will no longer be a standalone company. However, I note that utilities in our neighboring states in the Southeast have virtually all become part of multi-state holding companies. Mr. Chairman, lastly, I would like to thank all the parties that participated in this proceeding, and until just a few minutes ago, for the way you conducted yourselves, for your hard work, your viewpoints, your information, ideas that you brought before this commission. It was certainly valuable to us and brought a lot more into the record by your participation. It actually was good to see all of you participate and show your interest, concern, and passion for our great state and its citizens. Mr. Chairman, again, as you have stated, we cannot make everyone happy. But it is my belief that Commissioner Elam's motion is our best path forward, and I support his motion.
Thank you, Commissioner Whitfield. Commissioner Hamilton.
Thank you, Mr. Chairman. Mr. Chairman, my path in this journey has been kind of a long one, too. Mr. Commissioner Howard, I didn't realize you and I both had the same thought of no merger, and I thought that was the right thing, and hopefully it would work out. But as we received testimony and started the case, it became evident to me that if we continued the path that I had hoped this commission would follow, that it would lead the company into bankruptcy, and the ratepayers would be worse off now than they were when we started. From information that we received during the case, we found out that, again, rates for our ratepayers in South Carolina will be competitive in the Southeast. And our industrial rates will be very competitive, which should lead to economic growth again in South Carolina that would mean a great deal to everyone sitting in this room and all the ratepayers in the state. Again, I know some are not happy, but the decision has been made, and I hope we'll join together to see that the combination of SCANA and Dominion will be a perfect thing for the state of South Carolina. Thank you, Mr. Chairman.
Thank you, Commissioner Hamilton. Commissioners, Commissioner Williams.
Thank you, Mr. Chairman. Unlike Commissioner Hamilton and Howard and Whitfield and Elam and even the chairman, I'm new to this commission. And while it's been a long-fought battle going way back to 2008 or even earlier, I'm relatively new to even the issue. And my goal as a commissioner was to get the best possible deal for the people of South Carolina. And it weighed heavily on my heart that a company like SCE&G would no longer be a standalone company. And one of the reasons I appreciated the thoroughness of the parties in presenting their case to this commission is because right now, today, we're going to make a decision based on the evidence presented. And 10 years from now, it's going to be hard-pressed for us to say that we didn't know something. We know all the facts. We know all the consequences. There are going to be some folks that are working at SCE&G now that in July 2020 may not be working there. There may be some folks that leave even sooner than that. and that's an unfortunate consequence of this merger. But on the other hand, we don't know whether or not SCE&G could stand alone, as much as we may want them to, especially considering all the testimony that came out from current employees and even independent experts. And with the stakes so high, it would be very dangerous for us to pursue a course that does not have any certainty. And one of the things I appreciate about Commissioner Elam's motion is that it provides some certainty. So while we don't know exactly what's going to happen with those jobs down at SCE&G, what we do know is that Commissioner Elam's motion is going to allow for Dominion to come in biannually and give us a report, at least for the first 3 years, about what's happening with employment, how many folks are accepting packages, what are the current state of affairs. So at least we can keep a watchful eye. And while we appreciate Dominion, and I would even go to say that we trust them, we still have to verify. We have to verify, and I appreciate that element of your motion, Commissioner Elam, to make sure that Dominion comes in and gives a report to this commission on what's happening with their employees. I also appreciate Commissioner Howard asking one of the Dominion employees about low-income people, because we have a lot of folks on a low income here in South Carolina. And so it's important that we make sure that we think about those folks. And I strongly suggest that Dominion implement the program that they have in Virginia currently, where a customer can round up on their bill to make sure there's a pot of money for some of those folks that are not doing so well. I also strongly suggest that the basic facility charge remains close to what it is. I think it's around $8 for SCE&G. Because we don't want those people who can't speak for themselves to be taken advantage of. And I also appreciate Dominion agreeing to spend an additional $1 million in the community in addition to what SCE&G has historically contributed. SCE&G has been a good corporate citizen up until this point, and we want to make sure that that presence is continued to be felt in the community. We have a great coast here, and it may be possible for Dominion to have a shareholders meeting somewhere in the state of South Carolina, or even a board of directors meeting to make sure they stay fully vested in the state. And finally, also appreciate the fact that this process has allowed the Solar Business Association, Alliance, I should say, to get some concessions and to make sure that solar can continue to be a viable part of South Carolina energy generation. Mr. Chairman, you said it once and you said it again. No one will be happy with any decision that we made here today. Whether we adopted Plan BL, the original customer benefits plan, the ORS plan, or we shot down the merger and forced SCE&G to go at it on their own. No one would be happy, not one soul. But at the end of the day, it's incumbent upon us to make a decision that provides the greatest good for the greatest number of people here in South Carolina. And Plan BL does that. Commissioner Elam, thank you for your motion, and I'm happy to support it.
Thank you, Commissioner Williams. Commissioner Elam.
Well, just so I'm not really commenting on my own motion, I guess, I thought I needed to clear up a couple of things from the hearing. Near the close of the hearing, I asked Dominion to provide different scenarios if they were going to split up the amount of money between refunds and reduction of rates going forward. What we got showed that the ORS position to go strictly with the rates going forward was the more desirable one. Customers would have been paying back whatever they would have gotten from a refund in a short time, and for the remaining 20 years would have still been paying more than they would have otherwise. So that's what got me there. I was kind of like Commissioner Howard. I initially thought that SC&G could weather this, whether it was through some type of securitization or selling an affiliate. But the simple fact is they chose not to do that. And where we are now, I believe that this plan that Dominion has offered will create the certainty. It'll create the certainty in rates for customers, for the business community, for the economic development community. This will not have anything hanging out there. So that's what got me there. Staff may tell you that I got there kicking and screaming, but I'm comfortable with the motion as I made it. And I thank you, Mr. Chairman.
Thank you, Commissioner Elam. Commissioner Urban.
Thank you, Mr. Chairman. I appreciate the hard work that my fellow commissioners have done in this case. And while I'm in general agreement with the motion that has been offered, I have some alternative amendments that I'd like for the commission to consider. Of course, we're going to file a formal written order in this case on or before December 21st, 2018. So we're working on a proposed order. It hadn't been finalized, but my preference would be for the commission to find that as a part of our prudency determination that SC&G intentionally hid significant and relevant information from the commission and from ORS. And specifically in the March 2015 filing, SC&G misled the commission by failing to disclose its own internal cost estimates, which estimated the project would require an additional $1.2 billion to complete. Instead, SC&G senior management made the conscious decision to only inform the commission of the consortium's lower forecast of cost of $698 million and its constrained substantial completion dates. Now, SC&G engaged in a second serious act of deception by hiding both the existence and the results of the Bechtel assessment from the ORS and from the commission. Instead, SC&G made a decision to knowingly promote the consortium schedule of completion as an accurate schedule for the project. And for those reasons, I believe that our formal written order should contain a finding of fact and conclusion of law that any and all costs that were expended after the March 12, 2015 date should be disallowed. I think that finding is important for the factual basis that is required by law to pick a date. And it's not just enough for the parties to agree on a date. In my view, we need a specific finding as to why the March 12, 2015 date is the date of disallowance forward. The next thing I wanted to offer to my fellow commissioners for consideration is an amendment to the motion which would adopt the analysis of Mr. Baldino, who is the expert witness called by the Office of Regulatory Staff. He went through several great lengths in explaining how he arrived at return on equity of 9.1%. And I'm not going to read the entire testimony. We all know what he said, but just to reiterate, he ran the analysis through reliable, recognized standards from around the country, and it's his expert opinion that a 9.1% return on investment is appropriate based on current market conditions, primarily using the DCF model. The DCF model relies on current stock prices in the marketplace and has normally been regarded by this commission as the best indicator of the returns investors are requiring in the current marketplace for investment-grade regulated utility companies. So there's certainly a strong, substantial support for his opinion. And alternatively, I would move to strike 9.9% return on equity and substitute 9.1% return on equity. And I've got a couple more. Do you want me to stop and you want to vote on them as we go? You want to hear them all first?
Let's hear them all, and then we'll
Okay.
come back.
All right. The next area that I wanted to ask you to consider would be the findings on the merger condition that relates to affiliate transactions. And we heard a great deal of testimony and evidence presented by the parties and intervenors about how that might affect the ratepayers going forward. While the joint applicants affirmed a commitment to work collaboratively with the Commission and ORS should the merger go forward, it's clear that Dominion will have significant control over the sale, distribution, transmission of natural gas in South Carolina. And while they don't have current plans to expand their Atlantic Coast pipeline into our state, I think it's fair to say that they most likely will. And when they do, that opens up the possibility that SCANA would be purchasing natural gas from Dominion, and this would be an affiliate transaction, which I believe ORS has made a significant contribution by giving us some guidance to protect South Carolina's captive ratepayers to the risk of overpayment. So I would move that their recommendation as it relates to a merger condition on affiliate transactions be adopted in its entirety, beginning with page 107 of their recommended commission findings and continuing through page 108 and top of page 109. Otherwise, I think we run the risk of having another boondoggle down the road for ratepayers when they're captive and really won't have any say on how this would be handled. The next item that I want you to consider is the most favored nation clause. ORS has recommended that the Commission adopt a most favored nation clause in its final order. And what that would do is guarantee that both SCE&G electric and natural gas customers would receive pro rata benefits and protections equivalent to those that may be approved in another state jurisdiction. We heard testimony about that, and I think it would be beneficial to the ratepayers to have that protection. And if we could take up those amendments with those protections, in addition, if they're included, I'm in position to support the merger with those amendments and conditions, Your Honor, Mr. Chairman.
Okay, let's go back to Amendment 1, and let's have comments and restate that one again, Commissioner, and I want to ask other commissioners.
Yes, sir.
What the motion itself would.
Yes, sir. The motion itself would require a finding of imprudence by SC&G for the reasons I stated earlier. I believe that the law would require a finding on imprudence for us to. We can't just pick a date out of the air, and I don't think that parties can really stipulate a date. I understand they don't really oppose it, but we've heard from some intervenors that have other ideas. So I think there needs to be a factual basis for the March 12, 2015 finding of imprudence.
Okay. Commissioner Elam.
Mr. Chairman, I guess it's on me. It's my motion. As I first understood Commissioner Irvin's motion, it was that the commission find that SC&G intentionally withheld information and that they misled the commission. I think the motion addresses the fact that we believe we were misled. It also recognizes, I think, that it's really not. It doesn't directly impact the date they got to with ORS. The March 12, 2015 date, I believe, is supported by ORS's position in the case, that is the point after which they can, with a large enough degree of confidence, make a case that SC&G was imprudent. They have not stated that they believe there's at least sufficient evidence to go back further as far as disallowing any cost recovery.
Commissioner Elam, just to be clear, I'm not suggesting we go back further. I just think there needs to be a factual finding because this order is going to have precedental value. And what it does, it puts all utilities that are regulated by the Public Service Commission on notice that if they do in the future hide or misrepresent facts that should be known to the Office of Regulatory Staff and the Commission, that they are subject to a finding of imprudence. And so for the precedental nature of the order itself, I think we need that finding.
Mr. Chairman, just point of clarification.
Yes, sir.
And Commissioner Irvin, you tell me if this is correct. What I hear you saying is that you want us to address it very specifically as opposed to casually stating that there may or may not have been a deliberate attempt to mislead the commission and actually pick a date.
Yes, sir. That's exactly right. I think it's very important for a number of reasons. It lets the public know that this kind of conduct is not going to be tolerated in the future, and not just by SC&G, but any regulated utility that comes before us. If they choose to hide or mislead, misrepresent facts willfully and knowingly when they're sitting on the truth and not sharing it with us, that is conduct that has to be recognized as imprudent, to say the least. And we need a specific finding, for no other reason, for the precedental value of it.
Commissioner Elam, let me ask you this, sir. Would such a finding kill the merger, in your opinion?
No, I don't know that it would. I mean, I just think that given where SCE&G is and where the Office of Regulatory Staff is, that finding is unnecessary, and I don't know if that crosses over a little bit into a criminal element to that some of these executives may be facing. I just don't know that it is necessary to the ruling. In concept, I will say, yes, I believe we had information withheld from us. I think everybody has said that. As far as intent, I don't know that we necessarily have adequate information to establish that kind of intent or whether that matters.
I'm going to ask everybody in the audience to please be quiet.
And I think that the order, the result is an implicit, at least, recognition that we didn't have all the information that we should have had.
And, Mr. Needham, I simply point out that we have a different burden of proof. As you know, anyone that's accused is presumed to be innocent until proven guilty beyond a reasonable doubt. And so we're not talking about a criminal finding at all. What we're talking about is just by the preponderance of the evidence. The commission finds that it was imprudent. And under the case law, I think that's required for us to, we can't just pick a date out of the air. And the parties shouldn't be allowed to stipulate a date, in my view, because the other interveners were working toward an earlier date. And they presented testimony and evidence about that. I don't think they met their burden of proof. But I'm willing to go with the March 12, 2015 date, but it has to be a factual basis for it. And that factual basis is the willful conduct of SE&G. And I would encourage the commission to adopt it as part of its final order.
Commissioner Elam.
I believe that ORS's witness Jones provided the basis for the March 12, 2015 date. Beyond that, like I said, I don't know that it's necessary to the decision, and the effect of it is the same. And I guess I would, unless there's something else from, I'd call the question.
Okay, hang on. I'm going to confer with our attorney for 1 second, and then. All right, Commissioner Williams, did you want to say something else? You had your line.
I believe has the question been called on the amendment?
I did, but I wanted to make the motion's been made. And we're gonna.
No, I'm good. I'm good with the question.
Okay, all in favor of Commissioner Irvin's amendment, please say aye.
Aye.
All opposed, no. And the motion is defeated. The amendment is defeated. Okay. Next amendment. Please be quiet. Okay, Amendment 2.
Amendment 2 was the motion to insert 9.1 return on equity.
I think that was 3. You were
Okay,
talking
I'm sorry.
Bechtel. Something about Bechtel was 2.
That was part of my number 1, actually.
Oh, okay. All right. I'm mislabeled. Sorry. Okay, so let's go back and state that as a motion.
Yes, sir. The Baldino expert witness by Office of Regulatory Staff went through an analysis and which is widely recognized in the industry, and found that 9.1% should be the return on equity in this case, and I so move.
Okay, you've heard Commissioner Elam.
The response I would have is that the late filed exhibit that I requested, requesting where the rates would go if the calculations were based on 9.1 versus 9.9, showed a very de minimis reduction in rates. Dominion had a footnote saying that it would mess up the merger economics, and I don't automatically buy into that, because there have been other things that, in this case, that would mess up the merger economics but didn't. It just got down to the point where getting the certainty and getting this done, this is another one of those things I was dragged kicking and screaming on, but enough of a difference. There was not enough of a difference to make this a deal killer. So that's why I agreed to this, and why I believe we should stick with the 9.9.
Mr. Howard.
Mr. Chairman, I looked at all the ROEs 2017, and the average of all those ROEs nationwide was 9.5. I personally feel 9.1 is too low. We've got a lot of things happening in the electric market, grid modernization, all this, and I see the need of having to go to the capital market for infrastructure improvement, among other things. I don't think 9.1 would be an attractive percentage to go to the market with. I feel 9.9 is much better. 9.6 would be the average. Baldino mentioned 9.6 being the average in his testimony. However, in his motion, he put 9.1. So 9.1 and 9.9 are the only two numbers that we have in the record as a part of the case. So consequently, with me thinking 9.1 is too low to offer marketplace, I would go to 9.9.
Mr. Chairman.
Commissioner Williams.
Commissioner Howard, do you know the difference in 9.1 and 9.9 ROE on the average customer's bill?
I would yield to Commissioner Elam. I think he did those things. I think like 50 cents or something.
It was 32 cents a month.
Okay.
32 cents a month per ratepayer for 20 years.
Commissioner Elam, do you think so we're talking about 32 cents a month on the average customer's bill between 9.1 and 9.9. That's right, Commissioner Elam? That's right. Now, has Dominion, maybe I misread, but my understanding is that if we adopt a 9.1 rate of return, or ROE, that Dominion would walk away from the merger.
There was a statement saying that it would negatively impact the merger economics. I don't know that that's a full-blown walk away. Probably something more along the lines of they think they've gone far enough. But I wouldn't put words into their mouth.
Chairman, I move we call the question.
Okay, I just want to make sure everybody had a chance to speak. Anything else before we vote? Okay, on Commissioner Irvin's Amendment 2, all in favor, please say aye.
Aye.
All opposed, no. And the amendment is defeated. Okay, next one, Commissioner Irvin. This is on the merger conditions.
The merger condition that was recommended by the Office of Regulatory Staff on affiliate transactions. I don't need to read over the whole thing, do I? If you can go to the order itself and read them, but it's. I've moved that we adopt the merger condition that was requested in the ORS proposed order.
Commissioner Elam.
which condition are you referring to?
I believe it's on page 171. Let me check. It ties into the Atlantic Coast Pipeline concerns, and there's a discussion of it in two different places in the proposed order. I would call your attention to pages 133 and 134 of the proposed ORS order, but essentially the the motion is that we should scrutinize affiliate transactions and that regulatory conditions should ensure a vigorous ongoing oversight of affiliate transaction. And the Commission, in its final order, should find that neither SCNG nor any of its subsidiaries over which the Commission has jurisdiction shall enter into any contract for the purchase of gas or firm transportation capacity that entails transportation using capacity on any interstate natural gas pipeline where such capacity does not already have a certificate from FERC, unless the company proves in a public proceeding before the Commission by preponderance of the evidence that the company has identified and determined the date and amount of new fuel delivery resource it needs, objectively studied all available alternative fuel delivery source options, including options other than such contracts to meet the identified and determined need, and determine that such contracts were the lowest cost available option, taking into consideration fixed and variable cost and reasonable projection of utilization.
So you're concerned about the least cost element of that?
Yes, sir.
I think we dealt with that. There was the request about
it doesn't require a hearing, though. The language that we adopted doesn't require a showing or a finding by the Commission. It's
Mr. Chairman.
more of a suggestion.
Mr. Chairman.
Yes, sir.
If I may, I don't know
Whitfield.
whether Commissioner Elam is going to accept this amendment or not, but I would point out that this was vetted very thoroughly during the hearing, and that wholesale gas sales are a FERC jurisdiction, not jurisdiction of this state commission, and that there are two settlements. That one, a Transco settlement, and then there's another settlement between the joint applicants and Transco, and I would also note the Solar Business Alliance, where a lot of concessions that Commissioner Elam referenced earlier to Mr. Witt were granted. Also, there were concessions granted in a Transco settlement filed just before the hearing began that addressed these, and the Commission now has further tools that it would not have had that were only under federal jurisdiction. So, as Commissioner Elam mentioned, this is not to take place unless they're a least cost provider or with Commission approval. And also, the witness stated on the stand for the company, Ms. Jackson, that they would not be buying greenfield pipe supply over incumbent pipe supply that's already existing because of the economics of it, and that part of the settlement they will have to go out for an RFP. So, Commissioner Elam, I would leave you with those thoughts.
Commissioner Elam.
I think my motion dealt with this. There were affiliate transactions, and we talked about the ORS seeking a requirement for competitive sourcing. And what we did was remove the phrase least cost from that, because we said that while least cost is our goal, we don't want to set that as unmovable block to some other reason the company might have to enter into some arrangement that is not the absolute least cost.
And that's why it says or commission approval.
And what we're talking about here is that if they go out, if Dominion goes out and tries to source gas supply, if it's not the least cost, they are going to bear the burden of proof to show there was a legitimate reason that they did not go with the least cost. And given the way the gas supply market is and the involvement, I think we will hear from vendors who perhaps are looking to enter into agreements with Dominion that if they believe that Dominion improperly engaged in self-dealing. So I think, Commissioner Irvin, the motion already deals with that, and I don't disagree with what I think you're saying, but I think I've already dealt with it.
Okay, any other commissioner comments? Okay, all in favor of Amendment 3?
Aye.
Aye.
All opposed, no. Okay, and the amendment is defeated. Okay, Amendment 4. It's the most favored nation clause, I think. You want to? You said you just want to adopt the most favored nation clause, so that
From the ORS proposal.
From ORS proposal.
Yes, sir.
Okay, Commissioner Elam.
In principle, I don't necessarily disagree with the idea, but if we're truly talking about an apples-to-apples comparison, I think that the two states and the operating companies that are located there are different enough, both in the composition of the utilities and the regulatory structure, how the state looks at things, are different enough to where just a hard and fast apples-to-apples comparison as far as most favored nation. I mean, we deal with this in a lot of just even contracts that utilities enter into with customers, as far as if somebody else got a good deal, they want it too. If there is something particular that somebody believes is a condition that we should look at, I'm open to looking at it. But a blanket most favored nation in this kind of a market, I just don't think that it'll be free from problems if we go that route.
Well, the North Carolina Public Service Commission, when they took up the SCE&G Dominion merger, made it a part of their order of most favored nation clause. Provision is in the merger. Is that your understanding?
I have not really reviewed the record of that that I could tell you if they did, why they did. So I haven't reviewed that.
Commissioner Howard.
Chairman, Commissioner, I was under the impression that when North Carolina prepared their order, we still hadn't had hearings. So they didn't know what we were going to do. They were doing that to protect themselves. Our situation, North Carolina already have their orders. We know what's in their orders. We have every right to look and add anything they had in their orders to our order. So I question the need for a favored nation statute.
Well, it would mean, if we pass the most favored nation clause, it would mean that our gas ratepayers and customers in South Carolina would be entitled to the lowest price of the two states. Is that right? Correct?
I don't know that that's what most favored nation status conveys. There's just it's the difference between buying gasoline in South Carolina at the filling station and driving across the border and ending up in some sort of a different tax regime or whatever. I don't think that's what most favored nation in that context applies to. Subject correction.
So you're talking most favored nation. They're talking about merger benefits, right?
Right.
Any other commissioners want to weigh in on this?
Mr. Chairman,
Yes, sir.
I would just rise to speak that I share Commissioner Irvin's concern, but I do think it's addressed in the BL plan. And I do think, as Commissioner Howard said, we do, the North Carolina case has already occurred, and I think it's been addressed. But I certainly share his concern. However, I'm not sure an amendment is necessary to Commissioner Elam's motion to meet his concern.
Thank you. Any others? Okay, we ready for the question? All in favor of amendment number 4 from Commissioner Irvin, please say aye.
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 All opposed, no. And the motion is, the amendment is defeated. Okay.
Mr. Chairman, I
Yes, sir.
apologize. I had one more that I wanted to call to your attention, and that is the affiliate transactions merger condition, which is found in the ORS proposed order beginning on page 107. And again, it addresses the need for regulatory oversight when you've got the situation that we're faced with on affiliate transactions. And so without reading the entire page, I think that we should consider, if you look at page 107, 2/3 of the way down the page, it starts with a merger condition upon the joint applicants regarding affiliate transactions. The joint applicants did tell us that they will work collaboratively with the ORS and the Commission, and I appreciate that. But I think that it's what Commissioner Williams said earlier. We want to trust them in their word, and we do, but we also want to verify. And should the merger succeed and be approved by this Commission, I think it would be incumbent upon us to have a mechanism where we can review affiliate transactions, particularly those that could expose South Carolina captive ratepayers to the risk of overpayment. And there's a list of them. If you look on page 108, there's 6 provisions that begin with SC&G shall not be guarantor of any debt of Dominion or any other Dominion affiliate. SC&G shall make a filing with the Commission to seek approval of any structural reorganization and shall not implement any reorganization until the Commission issues an order approving, rejecting, or modifying the planned reorganization. The Dominion shall not modify its CAM or its affiliate billing practices to charge SC&G a rate of return on rate base. Dominion and SC&G and its affiliates shall abide by the standards regarding affiliate transactions as set forth in NARUC's guidelines for allocations and affiliate transactions, unless otherwise directed by an order of the Commission. And generally, the price for services, products, and the use of assets provided by a regulated entity to its non-regulated affiliates should be at a higher or fully allocated cost or prevailing market prices.
Commissioner?
Yes, sir.
Have you compared this list with the company's list of agreed to conditions?
If you can point to me that they've agreed to them, then obviously I'll withdraw the motion. But I was not aware that they were. Yeah, sure. This is the least cost thing. We've already dealt with that, right? And, all right, so our chief staff counsel tells me that apparently the joint applicants have agreed to all these conditions, and if that's the case, I stand corrected. Withdraw the motion. All the ones that I've read, yeah, so far. Mm-hmm. And I'm pleased that they did agree, because I think it's important for us to have the oversight. I think it will create an environment of transparency and accountability, and so I'm pleased to know that that was agreed upon.
Thank you. Okay. Commissioner Irvin, does anything else on those? Okay.
There's a merger condition that's found in ORS proposed order, page 142, and it concerns the Commission's public interest inquiry, and which is we're all aware that we are informed by the state energy policy. The South Carolina legislature's enacted legislation requiring a comprehensive state energy plan that maximizes to the extent practical environmental quality and energy conservation and energy efficiency, minimizing the cost of energy throughout the state. And that comes from our Code of Laws. I think that ORS is correct that in light of our legislature's interest in promoting these worthy goals that are outlined in the state energy policy, that we should impose a merger condition on the joint applicants, which would be in the public interest. If I can find my page number here. Want to ensure that the Commission, I would say the Commission should require that SC&G conduct an open, transparent, competitive solicitation for any new energy resources that may be needed to meet the company's energy and capacity needs. The language of the SBA settlement largely implements the condition envisioned by the Commission and is generally consistent with recommendations of witness Bentz and otherwise supported by competent substantial evidence. The SBA settlement is approved. Is that a part of your motion?
Yes, it is.
All right, thank you. Just want to make sure. That's everything.
Thank you. Commissioners, anything else? Anyone else have questions or comments before we take up the original motion? If not, all in favor, please say aye. Aye. All opposed, no. And the motion carries. Thank you. Okay. Just a few months ago, this commission was given this task of ruling on this case in a very aggressive time frame, especially given the fact that the last merger case heard by this commission took about a year and a half. Our commission staff and these 7 commissioners rose to the occasion to prepare this commission to come to a decision that we think is fair to all parties involved, and it's good for the state of South Carolina. It has not been an easy task. 15 days of testimony, over 4,000 pages of transcripts prepared by Ms. Wheat, and over 2,900 pages of pre-file testimony, close to 200 exhibits filed by all parties. And it's commissioners, commission staff has spent many late nights and weekends poring over all of this information to make sure that we've come to the best conclusion. We've learned a lot of stuff in these hearings, a lot. We were presented with a lot of information that we heard from the first time from all parties from both sides of this issue. It was information that may have made a difference earlier on if we had heard it, and everybody had information that we didn't, seems. And it's been stated several times here, and everybody's heard me say many times that this commission doesn't make the law, but we do follow it. And we've done that since the Base Load Review Act was passed, and we'll continue to follow that law as dictated by the General Assembly. With that being said, I'm glad that I saw that a bill on securitization has been given us, but with our order due on the 21st, it won't be a factor now, but if the bill becomes law, it gives some flexibility for everyone in the future. I notice the bill only applies to utilities regulated by this commission, but I'm confident that our lawmakers are aware that there are other types of unregulated utilities as well. On another topic, after reviewing Title 8, Chapter 27 of the South Carolina Code, which could also be referred to as the whistleblower law, it appears as if this law applies only to public employees. If such a statute were more encompassing to include employees of utilities regulated by this commission, perhaps some of the evidence that we heard during the hearing in November could have been heard earlier and would have been beneficial to this commission. My review of Title 58 of the South Carolina Code did not reveal any type of whistleblower law for employees of the utilities regulated by this commission. And in the regulatory world, as much openness and transparency as possible is critical for decisions to be made that are just and reasonable. I want to say thanks, like other commissioners, for our staff, for this group of commissioners. As you can tell, we've been through this in very much detail, and we don't all agree on everything, and that's okay. But I know that everybody on this commission, the one thing I hear from everybody is, let's do the right thing, and then, let the criticism come. I'll say, and I've said before and said again, that I'm proud to be a commissioner in the state of South Carolina and honored to work with these commissioners and with our staff. And with that, thank you, and we are adjourned.